Welcome to the HR on the Offensive podcast, a weekly podcast by Lace Partners, a fundamentally different HR and payroll consultancy. Each week, we tackle some of the most interesting topics facing senior HR professionals. So whether that's from employee value proposition, performance management, people strategy, or even payroll, we cover it all. So join us for the next 30 minutes. And if you like what you hear, subscribe wherever you get your podcasts. Now, on with the show. Good morning, good afternoon, and good evening, and welcome to the latest HR on the Offensive podcast. It's me, Chris Howard from Lace Partners, joining you as always for our weekly edition of this HR pod that we love to record and send straight into your ears. And today's podcast, we're going a little bit legal. We're going to talk about the Employment Rights Bill because at the time of recording, it's on the verge of being written into law. The Employment Rights Bill, of course, was introduced in October 2024. Our guest is probably going to correct me with all of the factually incorrect bits of information that I am going to bestow upon you, wonderful listener. But before we get into introducing our guest, I do enjoy having a co-partner, a co-host. And today it's the fabulous Chris Horton, who you've not been on for ages, mate, have you?
I haven't been. I'm starting to feel like you don't like me anymore, but no, I'm back. I'm back with a vengeance today.
He's back, baby. He's back. And we're going to hit him and me and our guest with a fundamentally different question, but we might as well introduce our guest first. It's Paul Chamberlain. He is Head of Employment at JMW Solicitors. Paul, how are you doing, sir? Back again.
I'm very well indeed. A little bit hot today. It's a bit humid up here in the northwest, but coping admirably, and it's very nice to be involved in this podcast series again, so thank you.
Yeah, it's great to have you on. I must say, humid in northwest and a little bit rainy down south doesn't sound right, but we're going to park that and move straight into let's do a little bit around yourself first, if that's all right, Paul, just for those people who may be, because you've been on the pod once or twice before, but perhaps just for the benefit of those listening in, talk to us a little bit about yourself and also JMW Solicitors, and then we'll get into the Employment Rights Bill right after the fundamentally different question.
Okay, so a bit about me. I've been doing this job now for about 32 years. I know you'll say I don't look old enough, Chris, but we'll leave that there.
Definitely.
So yeah, I've been a specialist employment lawyer for 32 years. I'm with JMW as head of their employment department at the moment, and JMW is a full-service commercial law firm. We have around about 600 people. We have offices in Manchester, London and Liverpool, and our turnover is very close to £100 million. So we're in the top 50 law firms, and I run an employment team that has 14, 15 people in it in the Manchester office. We've other employment lawyers in our London office, and I'm looking forward to talking to you about the bill.
Lovely. Before we talk about the bill, though, that is the tradition that I must enlist you two wonderful gents in being part of for this week. And that is our fundamentally different question. If this is the first time that you are listening in, we ask a completely random, non-HR or payroll related question. And today's question, let's give Paul a second or two to think about it, Mr. Horton. You're going to go first. Guinness, as in the Guinness World Records, are celebrating their 70th anniversary this year. And what they've done is they've announced that by telling people some of the world records that are still available. I'll give you three, but then my question to you, Mr. Horton, is what would you have as your Guinness World Record that you would like to claim? If it already exists, then you would get to reset it and claim it for your own. The three that Guinness World Records have announced: most whoopee cushions sat on in a minute, the fastest 400 meters sack race, very specific, like 450, 300, 100, but anyway, most high fives in 30 seconds. Mr. Horton, what's your Guinness World Record?
I think mine's a very easy one because it comes to mind very quickly. So I have an incredibly loud sneeze, to the point where my sneeze in our office, everyone will actually stop the call that they're on or the work that they're doing and just check that I'm still alive. So
I can confirm this. Yes.
Yeah. So without even thinking, I think it's just a very obvious one that sneezing is one of my talents.
Highest decibels for sneezing.
Highest decibels, definitely.
That's your Guinness World Record. Mr. Chamberlain, what are you going for?
I've been in training for one of those, believe it or not, Chris, this last weekend. So I would do the number of whoopee cushions in a minute, the most number of whoopee cushions. My youngest children had everybody falling around at a grandparent's birthday party this weekend by using an electronic one. Yeah, I was put through my paces, let's put it that way. So I think I would do that one justice.
There we go. So you don't even need to do a reset. You've already got one, which it can be claimed. I love it. Mine would be just as an excuse, really, to most Lego completed in a day. And it would just give me an opportunity to finish all the Legos I haven't finished and also start some new ones as well. I'm sure my wife would find that not a very productive use of my time, but what is a productive use of my time is talking about the Employment Rights Bill. So, Paul, I guess we've done a bit of an intro. It's probably worth starting as a top-line overview for those people listening in who perhaps maybe are less familiar with the bill. Can you talk a little bit around what is it and the impact it's going to have for HR teams, chief people officers, HR directors, HR teams listening into this podcast?
Yeah, well, this isn't a phrase I use lightly, but I do genuinely believe what I'm about to say to you. It is a generational change in employment law in the UK. The last Employment Rights Act was 1996, and everybody who was practicing at the time, including me, thought that was a significant change to the way we'd seen life beforehand. And this is even more radical than that. And we'll obviously delve into some of the details, but it is thankfully going to be brought in instalments, if I can put it in those terms. We're probably going to get royal assent later on this year. And then the government have produced a bit of a roadmap with the view to various provisions coming in at various points over the next 18 months to 2 years. If you look at it as a bill, you would probably lose weight if you thought that everything was going to come in at once. Thankfully, it isn't. But it is a fundamental shift in the way in which employers, employees and workers will relate to each other and the rights and obligations that they'll have towards each other.
And as we go through looking at the details and the roadmaps, Paul, what are the things that as an HR person you would be starting to really hone your skills on or your understanding of?
Yeah, I think if you're in HR, the 2 or 3 items that will jump off the page will be day one rights. So in relation to unfair dismissal, for example, proposal is that you will be entitled to bring a claim for unfair dismissal the minute you start, whereas at the moment there's a 2-year qualifying period. There is some debate, by the way, as to whether it will be a day one right. There's a House of Lords amendment that's been passed, which the government in the Commons will have to have a look at. Everybody is suggesting that they'll push back on it and say no to it. The Lords Amendment suggests that should be 6 months rather than a day one right. So that's the first big change. That will radically alter the way in which HR manage the process of disciplining people, dismissing people. And 2 other things I would mention very quickly. One, changes to statutory sick pay, which are going to be effective as from next April. So that's one of the earlier changes that'll be brought in by the bill when it becomes law. And I'll talk in a little bit of detail about that later, I suspect. And the third is time limits. I'm thinking specifically here about HR. So at the moment, most employment tribunal claims have to be brought within 3 months of either the dismissal or the discrimination or the cause for the claim. There is a proposal that 3 month time limit should be extended to 6 months. If you're an employer or an HR manager and you're biting your nails waiting for 3 months to expire, you've got a little bit longer to bite your nails before you're out of the woods in relation to a claim. There are other bits and bobs within it, but I think if you were to ask me for the headlines, it will probably be those 3.
And I always think it's interesting when legislation is passed or suggested and then it takes time for royal assent and then there's different roadmap and timings. What's the best way for people to keep up to date, to know what they need to actually be focusing on?
There are government publications. The House of Commons or Parliament website will tell people when the Act has got royal assent. There's already a published roadmap, which I think is a government department document. So if you go into gov.uk, you'll find that. And that's pretty clear. I'm assuming the government are going to stick to it. So if you want to put triggers in your diary as an HR professional, the roadmap is a very good document to look at. All I'd say is that don't be lulled into a false sense of security by that, because you might see something which is only going to come into force in 2027. and you think to yourself, oh, I can fold my arms here and have a cigarette and just relax and nothing's going to happen too quickly. There is going to be a lot of prep needed for some of these changes. So yes, you may only have to actually deal with it in terms of a legislative change in a couple of years' time, but I think you will certainly have to do some prep for it. So yeah, the obvious would be keep in touch with us. We are updating clients and contacts as and when we get any news, and we use update services as well. There are various sources that people can look at to keep themselves appraised.
Just linking onto that and thinking about that prep piece, Paul, and actually, Chris, it might be worth getting your view on this as well, because as an organisation, what we do, we spend a lot of time with our clients or with companies that we're friendly with, talking about things like the technology that they have embedded within their systems, and making sure that they're keeping up to date with the latest patches or upgrades or whatever it is. But this bit is more around, I'm thinking more around a data point piece here, and I'd like to get your views on what impact HR teams, or what things HR teams might need to start thinking about with regards to the types of data that they keep. Because I think about, at Lace, we're a 100-person business, right? We can keep track of certain types of information using our systems because we're a lot smaller. But when you get into 25,000, 50,000 people, the reliance on data, when you think about things like access to the flexible working, who's requested that, or rights from day one, what are the types of data points or things, Paul, do you think that HR teams are going to need to start prepping for? And then actually, Chris, it might be worth getting some views from you on that as well, about what HR teams need to think about from a data perspective.
Yeah, that's a tough question, because I'm obviously not at the front end in terms of managing people, certainly not on a large scale. Let me take one of the things I've mentioned to you, which is the day one right in relation to unfair dismissal. There is some suggestion that there might be some sort of statutory probationary period, which is not a qualification requirement by the back door. Many people have explained it as that. It isn't. What the government are proposing is that for a period of time after someone starts, it will be a little easier, if I could put it in those terms, for employers to lawfully dismiss someone. And that probationary period, we think, could be 6 or 9 months. I think most bets are on 6 months. So for a 6-month period after someone starts, yes, they will be able to bring a claim for unfair dismissal because there won't be a qualifying period, but it will be a little easier, or there will be some concessions made to employers to enable them to effect a fair dismissal within that period. Now, you're asking me about data. To a large extent, and maybe this is the lazy HR professional, but I have seen it because we prep cases for trial. Sometimes there are very few records kept or any data preserved in the period leading up to the current 2-year qualification. So I see, for example, performance-related dismissals where no formal or informal warnings have been given to anybody in the first 2 years of their employment. Then out of the blue, the employee is dismissed. They then claim some form of unlawful discrimination because that's the only claim that's available to them in the circumstances. That doesn't require a qualifying period. And when the client is then asked about the reason for termination and they say it was performance related, the problem they then have is adducing any evidence to show that performance really was a major concern. So I think there are going to be changes in mindset, because with a 0 qualifying period for unfair dismissal, that evidence is going to be even more crucial than it would have been if we'd kept the 2-year qualifying period. So that's the one that jumps off the page at me, Chris, in response to your question around data.
And I think, so for example, let's use the flexible working principle where people can effectively request to flexibly work. Now, as an employer, you can refuse that request based on an appropriate reason. To me, it's really making sure you're clear on your policy, but you're also clear what are the substantive appropriate reasons, and are you recording those so that there is a record of the discussion that's taken place. And I think the interesting thing in a lot of these things, when it's a smaller company, probably HR can be involved more, but in larger companies, if you're managing, say, a team of 10 people, and let's say it's a hospitality environment where actually flexible working may not be an option or may not be that easy to affect, to me, it's very much on the line manager to know what discussion they have, know the way that they should talk through the reasons, know how to record that so that if anything comes up, that there is a factual evidence available to talk through. Now, in situations where it's fine, you would still want to record that, yes, you've had the discussion and that you've approved the reason for the flexible working, for example. But I think across the board, to me, it's very much making sure that we're keeping on top of dates and understanding whether something starts straight away or whether it starts after a period of time. But to Paul's point, I think the onus is very much on employers now to really manage performance, to communicate well, to record discussions and make sure that everything's clear. Otherwise, there are strong ways that employees can actually fight for their rights.
Yeah, and I think flexible working, Chris, is a really good example, because one of the things that's promised in the bill is a slight change to the way flexible working operates. I think when we were waiting for the bill, we thought there were going to be wholesale changes to the rules around flexible working. Funnily enough, there aren't. But the one change that there is going to be, which goes directly to your point, is that employers will be under an obligation to more transparently justify any refusal of a flexible working request. So that absolutely goes to data, because if you're under an obligation to give a bit more background and justification for a refusal, then data is going to be very important to back that up, because that could be an area where the decision's challenged.
I want to ask you a quick question. So, Chris, I'm going to need you to help me here, because in our chat, you posted an interesting overview of the most challenging measures in the Employment Rights Bill. So there was a survey of 300 UK HR decision makers that Chris has forwarded on to me. So what I'll do is I'll give the top three. And Paul, I just want to get your take on to whether or not you think, yes, in terms of the priorities of what HR decision makers are thinking about, do you think this should be the top, or is there anything you think actually I'd be focused more on this bit? And then, Chris, I just want you to just remind me where we got that data from as well, if that's all right. But bear with me on that one. So I'll give you the top three. This is the 300 UK HR decision makers, and it's in at number one. 22% of respondents said improved access to flexible working. Number two was 21% saying improved legal protections for workers taking part in industrial action. And number three was a requirement for organisations with 250 plus employees to publish equality action plans, including menopause action plans, alongside gender pay gap data. So those are the top three that, according to this list, HR professionals are thinking of. From your perspective, are you like, yep, that makes sense, I can understand that? Or are there any bits that you think, actually, if I was a HR professional listening to this, I'd probably be focusing more on something else?
I think it's a bit of a mug's game to push back on a survey like that. If that's what people are actually thinking, it's not for me to say whether they're focusing on the right or the wrong things. But I think the one area in that list of three that you have hit on that I didn't mention in my introduction is trade union rights. And the reason I didn't mention it is because there are a good number of employers throughout the UK that don't get involved with trade unions where unions aren't recognised. But if I give you this statistic, probably half of the bill, when it was published, related to trade unions and collective bargaining and industrial disputes. And in short, what the bill will do is it will remove a lot of the technical procedural requirements that trade unions now have to satisfy before they can call lawful industrial action. So it takes us back to some people have argued it takes us back to a pre-Margaret Thatcher era where trade unions had a lot more power. Now, is anyone too surprised about that when you look at how all of this came about? The bill was effectively published as a consequence of union pressure in the lead up to the election. So it's no surprise that unions are given more strategic authority, more power fewer requirements to satisfy. So out of those three, that would be the one that I would say is not a surprise.
Just to answer Chris Howard's question, so the survey is done by Cypher, 300 UK HR decision makers. I think the interesting thing is looking at different types of organizations, both from a size perspective, maybe whether you're in hospitality or retail versus a service organization. I think it's interesting, some of the items around 0 hour or low hour workers, for example, and looking at whether they need to be offered a certain number of guaranteed hours. I think that's going to be much more interesting for companies that where that's the typical type of worker versus other organizations where you're a full-time employee. I'm really interested what you think about the 0 hour components and what's landed and whether there's been any changes to that.
It's interesting you raise that because, of course, with the work that we do in the recruitment sector, where a lot of temporary workers would be regarded as 0 hours contract workers for these purposes, this is turning the world of recruitment upside down, or has the potential to turn it upside down, because the proposal is that after 12 weeks, someone who is on a 0 hours contract will be entitled to be offered a guaranteed hours contract. They can, of course, turn it down. And that, I think, is the linchpin to all of this, because my experience of the recruitment sector is that a lot of people work as temporary agency workers because they choose to work as temporary agency workers. So the prospect of them being offered a guaranteed hours contract is probably not something they're particularly keen on. So I think there will be lots of temporary agency workers that turn down the offer of a guaranteed hours contract. But if you think about the potential ramifications, the guaranteed hours contract in an agency supply scenario has to be offered by the end user client. So the ultimate client of the agency will be the one that has to offer the guaranteed hours contract. So that means that the worker who was previously employed by the agency then becomes directly employed by the end user client. That client may have no requirement whatsoever for another member of staff, let alone anyone on a guaranteed hours contract. So from a public policy perspective, what you see here is government legislating to force an organisation that wouldn't ordinarily recruit to offer a contract to someone who's been supplied to them on a 0 hours basis by an agency. Now that, if you think about it in those rather stark terms, that is extremely radical. It's very radical indeed. And agencies are genuinely worried about what that might mean for their business model. There are other bits and bobs around guaranteed hours and 0 hours contract protections. What Angela Rayner said originally, you might remember, is that she was going to abolish 0 hours contracts altogether. She eventually realised that probably wasn't ideal for the purposes of a flexible economy. So she rode back from that and said, no, what actually we're going to do is we're going to get rid of exploitative 0 hours contracts. She's not even doing that with these provisions. None of these provisions ban 0 hours contracts. What the provisions say is that if you're going to offer a 0 hours contract, eventually after a qualifying period, the worker has to be offered guaranteed hours. So it's not a ban on exploitative 0 hours contracts at all. It's just imposing a whole raft of other obligations where 0 hours contracts are used. So if your clients, if people who you speak to use agencies, I think there's a big piece around all of this that they need to start discussing with their agency suppliers, because the world relating to the supply of agency workers and 0 hours contract workers will change radically when the bill hits the statute book. So there's a huge piece around all of that. And of course, Chris, you mentioned employers themselves who engage their own 0 hours workers. Well, these rules will apply just as much to them as they do to agency temps. So that is going to be a fundamental shift.
And depending on the industry and the sectors, as you've talked about, Chris, where you've got things like hospitality, where you have that seasonal fluctuation or demand and things like that's going to have an impact too. We've got about 3 or 4 minutes left just before we want to wrap up today. So I think really my sort of final question I wanted to ask, and then Chris, if there's any sort of bits that you want to riff off of it towards that as well, is more around if you're a chief people officer, chief human resources officer, if you're in a HR team at the moment and you're thinking about how and what we communicate back to our business or the rest of the C-suite, have you got any bits of advice for our listeners?
What we're doing quite a lot of at the moment is we are going into clients who are getting together their managers who will be responsible for making decisions around all of this. And we're starting a sort of program, a rolling program of education. In answer to your question, I think senior individuals within organisations shouldn't just get themselves comfortable with all of this. That's important. But I think the sooner they start to disseminate that knowledge and that information down to people on the ground, the better. Now, there's a danger attached to that because there's a lot of detail that we don't yet have. There are a lot of consultations that are about to start, which I think could change the direction of travel in relation to some of the things in the bill. So will be a bit of a movable feast, but the sooner people on the ground get to understand how these changes are likely to impact, the better.
And I think the really clear thing, Paul, to me is knowing the roadmap, knowing the sort of high-level key pieces of legislation that are going to go live at a certain time. I 1,000% agree with you that it's not just about HR getting comfortable with that. It's about leaders in the business. It's about line managers. So it's really, to me, thinking through what's the communication that you can give at this stage? What are the key pillars or key foundations that are already in place and we need to be starting to think about and work through? But then I think just flagging that these other things, that policy is likely to change, or that the way in which you capture information or share information is going to have to change probably at a certain point in time. So I think it's very much, to me, like any big program of change, it's basically going, here are the key things that we know and that are important for you to get on top of, but also here are the things that you need to look out for, and here's the rough dates to do that.
Yeah, and my final point, I don't want to be the Grim Reaper here, far from it, but remember this employment rights bill only has a portion of what the government proposed it was going to implement in relation to workforce employment changes. There was a whole document that was issued at the same time as the bill called Next Steps, which is everything else that they were proposing in the manifesto that they haven't got the, how can I put it, the courage perhaps yet to bring forward. We've got all of this in the bill. We're likely to have a lot more once the bill becomes an act and once the government have decided how they're going to take forward the other bits and bobs.
So if we look at it, national insurance contributions have increased the cost on employers of doing business. Like many things, that there's policy changes and different pieces that we'll have to do. Do you think there's going to be a significant cost to businesses, Paul, in implementing the things that are going to land?
Yeah, I think that is in a way self-evident. The changes to day one rights, or the introduction of day one rights, I think there are going to be more HR managers, more HR administrators required just to keep on top of the data. We talked about data earlier. There are definitely going to be more employment tribunals, and therefore there's an inbuilt cost associated with those. As everybody knows, even if you win a tribunal, you don't get your legal fees paid by the other side.
Yeah.
So there's going to be a cost involved in all of that. With the trade union measures, if more unions are recognised, there are a whole host of obligations that then go with recognising unions and the rights that unions then have once they're recognised, which will involve more admin. So yes, I don't think there's much doubt at all that there is huge cost associated with this. And if I might just make this as my final point, I don't want to be political about it, but it was interesting when the government said this was part of their agenda for growth. Growth and this bill, in my view, are not easy bedfellows.
A mic drop end there. I like that, Paul. Ending that with a slightly, not controversial really, actually, because I think there's a lot of what you're saying is fundamentally true. But again, as you said, not wanting to get too political as we finish up the podcast, lots to unpack there, lots to go through, lots of detail. If you want to obviously speak to Paul, you can reach out to him. It's Paul Chamberlain and then JMW Solicitors on LinkedIn. Thank you very much, Paul, for joining me.
You're welcome. It's been a pleasure.
Always a pleasure. And Mr. Horton, thank you very much for co-hosting.
Thank you. I'm off to practice my sneezing.
Yes, he's off to practice his sneezing. Hopefully you've enjoyed this podcast as much as we've enjoyed recording it. And if you'd like to, you can leave us some comments or make some suggestions on what you'd like to hear from. If you want to have a chat to Paul about other parts around the Employment Rights Bill, we'll also pop a link to his details in the show notes as well. But from myself, from Chris and from Paul, thank you very much for listening. And we'll catch you next time on the HR on the Offensive podcast. Bye-bye.